Welcome to the Topic 1 lecture in LWZ 304 Administrative Law. This is Introduction to Administrative Law, and you've just heard on the title slide an extract from Lou Reed's Perfect Day. Of course, every day that you study administrative law is a perfect day. That's what I think anyway. Now on this slide we see the reading for this week's lecture. The prescribed reading is chapters 1, 2 and 5 of your prescribed text by Crike and Macmillan, and or chapters 1, 2, 3 and 4 of the shorter textbook by Michael Head. There's also additional reading there, an article by Crike, an article by Wincop and Keyes, and a much more recent article by myself. Now, additional reading is exactly what it sounds like. You're not expected to do it, but it will enrich and deepen your understanding of the topic if you have time to do so. And certainly if you aspire to a distinction or high distinction, it's a good idea to at least read one or two of these additional readings. I am intending to set this recording so that the actual online versions of these articles will actually pop up for you in a separate browser window at some stage while you're listening to this recording. Not sure whether that will work yet, but if you see a couple of extra windows popping up, that's what it'll be. In the first part of this Lecture 1 recording, we'll be focusing on some administrative law theories. Now, I'll explain that in a minute on the next slide, in fact, but it's worth opening with a quote from Aronson and Dyer's administrative law textbook from some years ago, where they say this: defining administrative law is a topic on which few commentators can reach agreement, because it ultimately depends on what they want out of administrative law. We know what we want. As a minimum, we want a legal system which addresses the ideals of good government according to law. We take those ideals to include openness, fairness, participation, accountability, consistency, rationality, accessibility of judicial and non-judicial grievance procedures, legality, and impartiality. Now, that's a pretty significant wish list, isn't it, about what you want out of administrative law? And, of course, our system doesn't always achieve it. Although my view is that Australia's system of administrative law, and indeed system of governance in general, stacks up very well against the rest of the Western democratic world. Certainly stacks up well against the United States, at least under its present government, as far as I'm concerned. So to me, this is all an optimistic picture, but not a perfect one, obviously. It isn't actually a perfect day. It's a very good day, and that's worth celebrating, but it's also worth analysing, because we'll be going through the minutiae of administrative law this semester, starting next week with the Administrative Appeals Tribunal and VCAT and NTCAT and so on. Moving on from there to the Ombudsman, and then freedom of information, and then we'll start looking at all of the various doctrines of judicial review, grounds for judicial review of administrative decisions that adversely affect your client. But before we get into that forest of minutiae of the detail of administrative law, it's worth looking at some overarching concepts, themes, principles, and theories. And that's what this lecture does. The relationship between government and the community is complex and multifaceted, as the slide says. Government and the relationship between government and the people is vastly more complicated than it was when A.V. Dicey wrote about the rule of law back in the 1880s and 90s. In order for us to have adequate protections, if you will, from the overarching power of complex bureaucratic government. And indeed, in order for that complex bureaucratic government to be able to act in an efficient, effective, but fair way, we need a very complex range of governance measures to keep everything working in the best interests of everyone. Given that sort of complexity, no single theory of administrative law could adequately explain the legal accountability and responsibility of government. Theories of the admin law reflect different assumptions about the role of government and how the exercise of governmental power should be controlled. We'll be considering, in fact, some of these dichotomies or dualisms, as it's put, in admin law theory in this part of the lecture. Green light theorists and red light theorists. Can administrative law be regarded as or the governance measures be regarded as a partnership between courts and government? Well, maybe in some respect you'd hope that everybody operates reasonably cooperatively and that the whole operates harmoniously, but there's a difficulty with that in the sense that we have a constitutionally entrenched separation of powers between the courts on the one hand and the political arms of government on the other. So it can't really be a really close partnership between the courts and the government, but nevertheless, maybe that's a way to look at it to some extent. Administrative law versus managerialism is another duality that we'll be looking at, both in this part of the lecture recording and in the second part. Individualism versus collectivism. The democratic legitimacy of Parliament and the executive, and notions of political accountability. To what extent does political accountability of the executive, the ministers and the departments and agencies they administer, to Parliament, to what extent is that a useful check and balance? Judicial responsibility for safeguarding the rule of law, judicial deference to executive decision making. And so it goes on. We'll be looking at these things through this lecture.
Now, the first of the dichotomies that we want to focus on is what could be referred to as judicial regulation versus legislative or executive autonomy.
The next dichotomy that we need to be discussing is red light versus green light theories. Now, what the hell does that mean, you might ask? Well, the slide tells you, but the idea of this analogy or metaphor, if you will, of red light and green light theorists was first couched by administrative lawyers Harlow and Rawlings, and is summarised quite well in this quote from another administrative law academic. Administrative lawyers were divided into red, green, or amber light theorists. Red light theorists sought to stop the collectivist state from redistributing wealth and interfering with personal liberty and private property, and focused on controlling, in the sense of restraining, state power. At the other pole are the green lighters, who sought to use the law to facilitate the state to regulate, redistribute, and provide services. In between, as on a traffic light, are those under the amber light. These theorists, quotes, conceded the desirability and need for the exercise of public power, and thus reject the view that public law should be seen exclusively in terms of controlling or restraining such power, but would argue that reliance on traditional political techniques for promoting accountability and control is inadequate, and forms of political control need to be buttressed by legal control. That's administrative law measures and so on, ombudsman, freedom of information, administrative review tribunals, and so it goes. Now, before we go on with some further administrative law theory type dichotomies, let's just pause on the seminar question that we'll be considering about this in seminar 1, in week 1. Have a think about this, the red light and green light stuff that I was just talking about. What is the difference between red light and green light theoretical approaches to administrative law? Explain your answer by reference to a recent government policy announcement. For instance, the recent recommendations of the Banking Royal Commission, handed down by former High Court Justice Ken Hayne. Now, this will require you to do just a little bit of thinking and research before you come along to the first seminar. You'll be able to find the summaries of the recommendations of the Banking Royal Commission all over the media with only a little bit of Googling. Have a look at some of those and think to yourself, well, can they be categorised as taking a red light approach to the regulation of banking and insurance and so on, or a green light approach, or an amber light approach? Are they seeking to promote, keeping a rigid check on the way in which these things can be interfered with by the state, or some other approach? So we'll discuss that at least briefly in the first seminar. Now, our third dichotomy, if you will, individualism and collectivism, I apologise for the slight incorrect typing there, is also to some extent a slightly different perspective on the whole red light, green light thing that I talked about a minute ago. An explanation given in the previous quote as to why some administrative lawyers prefer restraint while others favour legal intervention has to do with a preference for an individualist or a collectivist view of the state. The collectivist view is premised on the belief that decisions have to be made within a framework of policy that recognises broader social concerns, such as the rational allocation of limited resources and the need for consistency and predictability in government administration. That perspective is generally taken by the legislature and the executive, where they're concerned with ensuring both distributive justice and horizontal equity. This view supports the need for judicial understanding or deference to the different role of the executive. The contrasting approach is that administrative review is properly concerned only with ensuring that individual justice is achieved in resolving the individual dispute or claim before the adjudicative body. Now, how that manifests in merits review tribunals, as you'll see when we get to topic 2 in week 2, is that there's an ongoing tension between those approaches in what approach a merits review tribunal should take. Should it just take an individualised justice approach and look narrowly at whether the particular decision that adversely affects the applicant is fair or unfair, and not look any further than that? But on the other hand, governments have to look more broadly than that. They have to look at consistency. They have to look at the distribution of finite assets in a fair manner between people. And therefore they can't look just at the individual best case result for an individual applicant. And because the decisions of merits review tribunals will generally substitute for those of the government department or agency, that becomes problematic. So therefore, to what extent should an administrative tribunal have strong regard to government policy about distributional equity and justice and consistency and so on, and not just look at the individual just result for the individual applicant? An interesting question, and one to which there's no perfect answer. Again, no perfect day. The next dichotomy in theory is that between rule-based and substantive justice. An ordered society requires people to comply with defined rules. A just society may look more searchingly at whether the rules comply with accepted universal norms of fairness and equity. Should administrative law just pursue formal legality or administrative justice? In other words, should form or substance triumph? A legal positivist view is that rules gain validity and authority through their process of creation and the sanctions that can be used to enforce them. The content of rules is important, but must generally be accepted once made. So, suck it up. The Parliament has made the law, the government has made regulations to further elucidate them, and if they're unfair in the individual case, well, too bad, you just follow them. But a contrasting view is that rules acquire meaning partly through the way they're interpreted and applied. In those processes, there is considerable scope to examine whether rules align with human rights norms and accepted moral principles and fundamental freedoms. Nor are all review bodies expected to take just a formalist rule compliance approach. A specific function given to the Ombudsman and similar bodies, and to a more limited extent administrative tribunals, is to comment on whether a substantive outcome is fair or defensible in a broad moral or human rights or freedoms sense. And that leads us to our next seminar question that we'll be again considering to some extent in the week 1 seminar. Is it best practice for Parliament and the Executive to prescribe detailed regulations and stipulations in policy documents which bind government decision makers and give certainty to the public? Alternatively, should decision makers be given discretion, guided by legislative and policy objectives? Identify the benefits and drawbacks to each approach. Well, just to give you a little bit of a hint there, there's two particular areas where Parliament and successive governments certainly have decided to adopt a formalist, detailed, prescriptive approach to regulations. And they are migration law and taxation law. In both those cases, the legal prescriptions in legislation and regulations are hugely detailed and not that much scope for individual discretion by a minister or public servant. It's a tick-a-box approach. You either meet the requirements for a particular migration visa or you don't. You're either entitled to a particular tax deduction or rebate or you're not. The criteria are spelt out in great detail. Now, of course, that certainly results in consistency and predictability, but does it necessarily result in fairness and flexibility? Those are questions that we'll consider in the Week 1 seminar. Contracting out a new managerialism is something that we'll consider here, and I'll come back to it in the second part of the lecture as well. What happens when governmental functions are contracted out to the private sector, for a start? Well, that's happened to a huge extent, both at federal and state level through the 1990s, especially in the beginning parts of the 2000s. So, at federal level, we saw the privatisation of Qantas, the privatisation of Telstra. More recently, we've seen the privatisation of job search assistance. That used to be handled by a government department attached to Centrelink. Nowadays, it's outsourced to jobs network providers whose job is to find jobs for unemployed people. Now, whether that system is better than or cheaper than, or perhaps both, than the public sector bureaucratic procedure that replaced it is a matter of debate, but it certainly happened. At state level, of course, state governments have outsourced and privatised a huge range of things. In many states, they've privatised the provision of power, water, sewerage. In some cases, of course, there's privatised roads, toll roads that are run by large private companies. Getting back to the federal government, they've privatised all of the airports. So all of the federal airports in every capital city are run by private corporations now. They used to be run by government. We've privatised prisons in some respects. State governments have privatised the administration of prisons. Of course, the federal government notoriously has privatised the detention of asylum seekers, both in offshore places like Nauru and Manus Island, and to a lesser extent in onshore detention centres. So huge amounts of privatisation of functions. In the Northern Territory, not so long ago, the Darwin Port was privatised. It's now run by a Chinese company called Landbridge. The Darwin bus service was privatised not so long ago. So a whole range of things that used to be thought to be government activities, that used to be therefore subject to public scrutiny, both by Parliament and by administrative law mechanisms like the Ombudsman, like freedom of information. They used to be subject to independent merits review appeals to merits review tribunals, like the AAT and so on. Well, where these bodies are privatised, all of that goes out the window. And instead of that, the philosophy is that competition between private providers will provide the best outcome or at least the cheapest outcome. Whether it provides even the cheapest outcome, I think, is a matter of question that we'll certainly discuss. But even where public sector functions are not actually privatised, increasingly they've been subjected to a method of management and oversight that is taken from private sector management. The accounting firm McKinsey devised something called new managerialism, and it's been increasingly applied to public sector management. So senior public servants are expected and required to adopt managerialist approaches involving, as the slide says, the unbundling of the public sector into corporatised units organised by product or service, more contract-based competitive provision with internal markets and term contracts, stress on private sector styles of management practices like KPIs. You might have heard of KPIs, key performance indicators. So your performance is measured, at least in some respects. Your manager is watching, is measuring, and Big Brother is watching. The cartoon, in a sense, talks about that, about the extent to which this is formalised and everything is measured. Everything involves filling in a form. More stress on discipline and frugality in resource use. So the efficiency dividend was something that is often applied in a managerialist ethos in the public sector. You have to do more with less every year. They'll shave a bit off the department's budget to save money, and hopefully they'll be able to do more with less. It's more likely they'll do less with less, or they'll do the same amount but not do it as well, but that's the theory of it. More emphasis on visible hands-on top management, so Big Brother is watching. Explicit formal measurable standards and measures of performance and success. As I say, KPIs. Greater emphasis on output control. So it goes. Interesting to talk about how well that works and how well it works within a system where we still have traditional public sector control and accountability measures like internal reviews and appeals, like the AAT and other merits review tribunals, ombudsman, freedom of information, and so on. And so that's precisely what we do discuss in a seminar question. What are the pros and cons involved in importing new managerialist management techniques into the public sector? Might there be a difference between public servants who are part of a profession, doctors, scientists, accountants, economists, lawyers, etc., and ordinary line administrators responsible for processing applications, inquiries, etc., from the public? In other words, to the extent that someone on the front counter is a bit like somebody on a process line in a private automobile manufacturer, bolting on a widget or something to the car as it goes past on the production line, it might be sensible and useful to impose managerialist approaches on making that whole process of application and processing of applications efficient and effective and consistent. But to what extent is that sort of bean counting approach, if you will, a useful one in managing the more complex, subtle, nuanced aspects of the services that governments provide, where that does involve professionals and so on, like doctors, scientists, accountants, economists, lawyers, and so on? I think that's a really interesting thing to study as well, and we will be studying it in the Week 1 seminar.
Now, it looks like I've got my slides slightly out of order here, but rather than reordering them and disrupt the recording of this presentation, I'll just commentate on them out of order. This is supposed to be the last slide, and it says, but wait, there's more. Those of you who are nearly as old as I am will remember that was a slogan by a company called Demtel, who sold lots of things, mostly by TV ads, and their favourite slogan was, but wait, there's more. If you ring in the next 5 minutes, you not only get the dicer, slicer, and carving knife, but you also get the blender, and you get the chopper, and you get all sorts of other things as well. So in this case, that's what I'm referring to. We now go on to part B of lecture presentation 1, Introduction to Administrative Law, where we look at some more theoretical or conceptual aspects of administrative law. What does it all mean, I say? Well, we'll see in the second part of the lecture, but before we get to that, I'm just going to focus very quickly on another seminar question that we're going to be discussing, and it was implied in my discussion a minute ago about managerialism.